Smartphones and other devices that we use every day similarly use numerous technical standards. But how do these standards come about? I'm Owais Siddiqui, Executive Director of Intellectual Property at HTC America, and I'm here to moderate a panel on standard setting organizations and the contractual model. Before we get started, I just wanted to give a reminder about the Chatham House rule. I think that was up on the slide before. Please respect the rule so that the panelists can feel comfortable speaking on all these topics. So let me introduce the panelists. Earl Nied is the U.S. IP Policy Director and Global Director on Intellectual Property Rights relating to standards for Intel Corporation. He chaired the ANSI Intellectual Property Rights Policy Committee from 2012 to 2015. He presently serves on the ANSI Board of Directors and ANSI Executive Standards Council. Earl continues to participate in the ETSI Special IPR Committee, going on more than 22 years, as well as many other STOs and international standard organizations. Carter Eltzroth is Legal Director of the DVB Project, the Geneva-based standards body setting technical standards for digital broadcasting and related fields. He's also the Managing Director of Helicon.net, which provides legal services to standards development organizations, to licensors, and to technology implementers. In addition, Carter is an arbitrator with the World Intellectual Property Organization. And at the far end, Patrick McBride is Senior Director and Assistant General Counsel for Intellectual Property at Red Hat, a subsidiary of IBM. With more than 30 years of experience, Patrick is an IP specialist for collaborative software development projects who's gained insight into the attributes of open collaboration and free public access to software and source code. He oversees Red Hat's participation with alliances, such as Open Invention Network, and manages the defense of patent litigation. Please join me in welcoming our panelists. All right, so my first question is, sometimes we hear the term standard setting organization, sometimes we hear the term standard developing organization. Is there a difference between the two? Carter, how about you take
Well, I can provide a little bit of a European perspective. There's a division within Europe between standard setting organizations and STOs, standard development organizations. Generally speaking, the SSOs are those that are recognized as such by the institutions of the European Union. So these are ETSI, which is the European Telecommunications Standards Institute, and CEN and CENELEC. And sometimes also we speak of SSOs, those international bodies, sit in Geneva like ISO, IEC, and ITU. Everyone else, consortia or otherwise, that develop standards are called standards development organizations, and they commonly, as is the case with my organization, they commonly hand off their specifications to a recognized standards setting organization like ETSI.
And how about in the US?
Well, this is Earl Nied from Intel. So in the US, it's a little bit more flexible. I would say from an Intel perspective, standards development organizations we look at as the official bodies, the incorporated bodies that are developing standards where everyone is allowed to participate. There's a whole number of other organizations, the consortia that Carter was referring to, that may also develop standards. USB would be an example. And those are a little bit different. So from an Intel perspective, we typically refer to STOs when we're talking about either the formal organizations, ISO, ITU, CEN, CENELEC, ETSI, and also for STOs, we would include all of those as well as the W3Cs, the IEEEs, the many other standards organizations, and then we would consider consortia groups that are put together for voluntary standards. All the standards are voluntary, but these are more groups of companies that have come together to put forward a standard for use.
So with that U.S. understanding of what an SDO, SSO, or roughly equivalent, how is a standard developing organization formed? Carter, maybe you could first give some examples.
I have a unusual anecdote, and that is that back in the early 90s, the European Union was heading toward the direction of adopting a television standard, a next generation television standard called D2MAC, and Brussels was all keen to move that forward. There were a number of technologists. This was the early 90s. There were a number of technologists who were convinced that the next generation should truly be digital, and somewhat in defiance of the folks in the European Commission, these leading technologists from a variety of institutions in Europe met together in secret in a German castle and decided that they wanted to move forward in creating transmission standards for broadcasting using new digital technologies, and also being able to implement, for example, the new video codec that had recently been adopted by ISO IEC. So they noticed the need. They thought that they could move forward, they could jump forward. They formed a group, a study group to see if there could be traction. There were more and more entities that decided to join, and ultimately the interest in Europe for D2MAC fell off quickly, and the focus was on the solutions being proposed by the DVB project.
Earl, do you want to comment on?
Sure. So I might add and look at it from a slightly more simple perspective, and that is what is motivating companies to participate and who's participating in development. It's a technical decision, and the people that are interested in getting together and working on a standard are technical people. So what they're looking for is they're looking to create a standard that is going to be usable, that people are going to be willing to adopt and incorporate and implement. So they want to know that there's no blocking patents, and they also want to know that there's no extreme encumbrances in the way, that there isn't somebody that might have a patent but might not be willing to license it on any sort of reasonable terms and create problems for the implementation of the standard. They don't spend a lot of time dealing with patents. They're looking at the technology that their company has and that other companies have. They're looking at how long it would take to produce products based on this new technology, and they've got to make a lot of decisions for very complicated standards these days in a very short period of time. So they don't have time to investigate patents, and that'll come up in our discussion later. But the motivations are technical, and sometimes there are also trade-offs with, we've got two pieces of technology, they're relatively equivalent, but in order to negotiate with other companies, we'll select one versus another. This is largely a technical discussion.
So let's talk about some of the other incentives that companies might have to participate in a standard setting organization. Carter, why don't you give your comment?
Well, in DVB, they could be pushing their own solutions. They could have had, they're interested in having their own solutions for a particular technological challenge ratified by a standards body, and so they make a contribution into DVB and they hope that it's adopted as the DVB solution. Coupled with that is perhaps the expectation that if they have filed patents that are relevant or essential to that particular contribution, that they will emerge as someone that will be able to enjoy revenues, royalty revenues. Others contribute engineers because they're looking for the best possible solution, and they don't necessarily have the kind of earlier they don't have, for example, an existing contribution to make or a preset idea about what they can contribute, and they just want to establish their mark in this particular area.
So Earl, I think you had some thoughts on companies' motivation and whether they're motivated by obtaining licensing revenue or technology.
Yeah, it all depends on the market and the company's business and where they are in their development of their business, et cetera. If we take a look at the ITC environment, you've got information technology and you have communications. If we were just looking at the information technology piece, most of the people that participate in that environment are not interested in seeking royalties. And there's a few that are, but they view it as a supplemental stream to their product business. It's companies producing products and they're making their revenues off products. They're using their patents defensively. They're using their patents in order to, as a trading item if they have to face cross licenses or other challenges. And so if it's just information technology hardware space, the vast majority of companies are not asserting patents for royalties. That's very different in the communication space. In the communication space, there are a handful of companies that royalties are very important to them, and it's important to their revenue and their business model, and that's the way the environment is. There are a lot of companies that participate in the communication space that don't have huge portfolios but have some patents, and again, maybe using them defensively or for other purposes, but revenues may not be their entire goal. So it really depends on the environment and depends on the company and their business model. And that can change as they go into different markets.
So Earl, following up on that, what kinds of commitments do companies undertake when they join one of these standards organizations?
Well, as I was alluding to earlier when we were talking about who's participating in the development, the idea is to create a standard that will be successful. So you want to make sure that nobody's going to block it. You're willing to contribute your patents. You want the other people participating want a level playing field. If I'm going to participate contributing my engineering or even approving your engineering, they're going to want to be able to compete in the market. They're not going to want a particular company to corner the market and to prevent them from competing or create a problem for them, from a standpoint of controlling their prices or whatever. This is why antitrust it looks over patents in standard setting with great scrutiny, because you could have monopolistic creations here, and they could be very detrimental to competition. A healthy standard will be accepted by a lot of people, and the people that are implementing the standard will feel comfortable that they can compete. The idea of someone actually wanting to get revenue from their patents, as long as the revenue stream is acceptable and reasonable and non-discriminatory in spirit, then things should work out well. We see today that people have different opinions on that, and there's plenty of disputes about whether someone is being reasonable and non-discriminatory.
And Carter, you had some thoughts on FRAND commitments in ETSI and also additional commitments in DVB.
Right, exactly. Well, in ETSI, companies that participate in ETSI activities always make the promise which Earl Nied has just described, and that is that if they're making a contribution or if they're participating in ETSI activities, their patents that are essential to ETSI standards will be available on terms that are fair, reasonable, non-discriminatory. There's a second aspect which is common, which is not only in ETSI, but is common to very many standards bodies, and that is that if you own a patent which is essential to an ETSI standard, then you declare it, and it's added, and that declaration is added to an ETSI database. So there's, and we've done, and a participant who couldn't be here today, a speaker who couldn't be here today because he's recovering from COVID, Christian Loyot, who is legal director of ETSI, he prepared a couple of slides to talk about ETSI's experience here. And I'm about to show my complete ignorance of this technology here because I assume that the green button advances the slides. So I'll see in a moment. This describes, in Christian Loyot's slide, this describes the process that a typical company goes through about deciding to make a declaration to ETSI. It goes through what's described as a self-assessment, the self-assessment of essentiality of one of its patents. In other words, it doesn't necessarily look to an outside expert to make confirmation that's essential. And then it makes a declaration using a form provided by ETSI. And on that form, it confirms its commitment to grant licenses that are on terms that are fair, reasonable, non-discriminatory for the use of that patent. And I'm wondering if the prior slide shows no. Okay. And Christian Loyot is keen to indicate that this is basically the IPR policy of ETSI. It stops at this point. It doesn't offer any views about what constitutes fair, reasonable, non-discriminatory. It doesn't go into the commercial negotiations between parties, which themselves set the terms of licensing. Within ETSI, and here I look a little bit to Earl to help me out on this. There are basically two ways that you submit you can submit declarations. One is to say, everything I've got, which could be essential to a particular ETSI work item, everything I've got, if it's essential, then I agree to grant licenses on terms that are fair, reasonable, and non-discriminatory. And then another way of doing it is being able to specify those patents, identifying the patents with particularity, and optionally also to identify exactly on what aspect of the standard that it reads. So there's two ways of doing it within ETSI, and Earl, Intel must file all the time, and so maybe you provide.
Yeah, so let me put a little bit of clarity to this. They're not actually an either-or proposition. In ETSI, and ETSI is kind of unique in this environment, ETSI and the 3GPP standardization community, they want an identification of individual patents. So again, remember my discussion about the developers. They want to know that the FRAND commitment is going to be there. So there's an encouragement to put in, a general disclosure early on to say you are committed to license on FRAND terms. However, they still want a specific disclosure identifying individual patents, including where in the standard those patents are infringed. That takes a lot of work. That takes a lot of legal department energy. It's not, sometimes you will have people participating in standards developments that are the brains behind certain technologies, certain inventions, and they're equipped to make that kind of information available, but there's background information, there's potentially patents that are infringed from other sources, et cetera. So actually identifying individual patents is what goes into the ETSI database. I want to make a specific point that the details on whether these patents are essential or whether the patents are even valid or infringed is not something the engineers participating in the development can make. You're talking about a legal determination, et cetera. And the self-declaration process lends itself to to you wanting to disclose a patent if you at all believe it might be essential. There are some court cases that have come up where if you don't disclose and later try to enforce, you might not be able to enforce. That's also promulgated in Europe, so ETSI, we'll see later in the slides, has a very large database of self-declared patents.
So should I move to that slide? Hopefully it's the next one.
There we go. Yes, it is. So we're not going to go over this slide in great detail, but I think what we'd like you to get out of this is the idea of the huge number of patents that are in play here. If you take a look at the line that says, you know, the number of disclosed essential patents, and you know, you've got a number in the tens of thousands for each year, that's cumulative. So, you know, when we're saying 15,000 in one year and 15,000 in the next, that means in the database there are now 30,000 entries, and then in the next and the next and the next. So if you actually look at how many patents are actually declared, it's an incredibly large number. The database is very unwieldy, and because of this idea that if you don't declare something as standard essential and you want to assert it later, people are over-declaring. It is estimated by the European Commission that only half the entries in the ETSI database are actually essential. So it's a good thought to have a database so you might get more information, but I caution people to always consider that this is distinct from what it takes to develop a standard versus what it would take to create a licensing database.
And then, Carter, you also had some thoughts on additional obligations that DVB has, arbitration.
So we've been talking about that, yes. We've been talking a little bit about European Telecommunications Standards Institute. Back in the 1990s, DVB learned from ETSI's experience, and we've created a different IPR policy, and it's somewhat unique. And let me see if this is the next slide. Well, I didn't realize that this was a slide that built. So DVB is one of the, I guess you'd call them a second-tier standards body within Europe. There's the recognized standards bodies like ETSI and Senelec. DVB is the consortium that got together in the German castle. Now we have some 150 members, and we're noted mostly for the creation of transmission standards for broadcasters in the digital environment, and those are the standards which are described in the lower left-hand corner. It's the T2, it's the DVB-S2 and DVB-T2 transmission over the air and satellite transmission standards. And then we've been moving into other domains as well to accommodate, for example, the efforts in the 3GPP activity and broadband distribution. But I'm not here to give a puff piece for DVB. I'm here to talk about our IPR policy and about the differences between DVB's IPR policy and ETSI's. There's 4 points with respect to our IPR policy. Nothing surprising. Every member is obligated to grant licenses that are on terms that are fair, reasonable, and non-discriminatory. But there's no positive declaration provision. You declare negatively if you cannot give a license on those terms. We have 2 specified windows when a company gives those kind of negative declarations. Let me just say in passing that the policy's been around since the mid-1990s. I've checked recently. I can give you now the total number of negative declarations we've received since 1997. It's 0. No company has ever indicated that it was unwilling to grant FRAND licenses for DVB specifications. Our two other aspects, which are somewhat unique to DVB, is that we have an explicit provision requiring arbitration of disputes between members on whether they are adhering to our IPR policy, for example, and whether they are granting licenses on FRAND terms. And finally, another aspect which is important is that we actively foster the formation of patent pools with patents that are essential to DVB standards. We have an entire process which we've developed over the years in order to do this fostering, and as a result, many of our standards are in fact administered or in patent pools by commercial entities. So those are the primary differences between DVB's policies and the ones that the more typical policy that in ETSI that Earl has described.
All right, so a question for Patrick, who's been waiting patiently on the side. So Patrick, Red Hat is, of course, known for open source software. Do you have thoughts on how the open source model compares to the development of standards in standards bodies?
Sure. Thank you. So open source, of course, typically relates to software, and one of the wonderful things about software is that it's you can make an infinite number of duplicate copies of it without at almost zero cost. And so what this enables is a system where it's very easy to make an implementation of a standard if it's in software. And the open source model can be viewed somewhat as operating in parallel to the efforts that traditional standards bodies make to create a standard, and then everyone goes off and creates their own implementation. In open source, we sort of skip that standard setting process. What we're really trying to do is drive what we call a de facto standard that is built on top of a commonly accepted implementation that everyone uses, and they base their business model around that common implementation. In some cases, they will what's called forking, which essentially means they take the open source project and they'll go off and create their own version and try to create a different de facto standard, try to rally people around that. It's all a merit-based competitive process. The way that patents are handled in this process is there is no agreed upon IPR policy at a standards level, but rather there's an agreed upon license that's associated with the software implementation. There are various licenses available, things like, you might have heard the terms Apache, MIT, GPL, those sorts of things. They have different licensing terms related to copyright and patent, and in some cases trademark. But those license terms handle the IPR associated with all of the developers for the technology, and there's really no need to create a standard, create competing implementations of it, and then have a conversation with the IPR holders about FRAND terms, because that's all built right into the process of creating the technology in the first place.
So following up on that, we heard from Earl and Carter about the obligations that companies undertake when they participate in standards bodies. What kind of obligations do companies undertake when they join an open source project, and if you could compare them?
Sure. It varies. As you might imagine, it varies depending on the license that's been selected. There are some licenses that are more explicit about the patent rights that you're granting and so on. There are some that are, frankly, it hasn't been litigated, and so it's a little bit more vague. In many cases, the license is actually not specific to a type of intellectual property, so it will authorize, say, an act of running the code or something like that, which is not a statutorily defined term, whether it's copyright or patent. And so the implication is that whatever IP rights are necessary for the end user to do that flow with the code, whether that's copyright or patent. And so it's a lot of the licensing is handled by, or a lot of the IPR is handled by the license. Some projects have associated with them what's called it's either an assignment of rights or some sort of broader license. It's a contribution agreement is what it's sometimes called. So there might be, in order to participate in a project, there might be a contribution agreement where you are licensing your patents, your copyrights in a broader sense than the actual distribution license, primarily to allow those who are administering the project to change the license if they need to. And then there's also a body of entities that have built up in the open source community to supplement IP rights. I'm associated with several of them. One of them is called the Open Invention Network, which is a patent cross license related to the Linux operating system that provides royalty-free patent licenses to all participants. And that kind of supplements all of the open source project activity around that particular technology.
So a concern is sometimes raised about the issue of over-declaration. Earl, how do various standards organizations handle the issue or the concern of companies over-declaring?
Well, I think as we noted, ETSI is in a unique situation asking for identification of individual patents. The idea was spawned out of an intention to do something useful in that, when you're developing a standard, those people probably have good insight to what patents are there, and it would be good to have a database of those things. However, as we see, it becomes unwieldy, especially when you have a situation where if you don't disclose it, you might lose it, lose the ability to enforce it. So it can take a lot of energy, a lot of legal energy, not just engineering energy, to come up with that information. And then you also have to maintain it over time. These standards exist for easily 20 plus years. And what might be essential today might not be tomorrow. It's also very subjective. Give any two lawyers the possibility of determining whether something's essential, you may get two different answers.
Or three or four.
Yeah. So lots of companies, there are, a couple of people are bad actors. They look to over-disclose just to overinflate their position and be able to walk into somebody that might be a licensee and say, hey, I've got 5,000 patents you might infringe here. Let's talk about how much you owe me. Or, it's more likely than not, it's just everyone has to make the determination of how much energy they're going to put into this and where they're going to actually declare a patent to be essential and where it's just going to be too expensive to go much further. So the number is difficult to come by, it's expensive, and it's difficult to maintain. With the ETSI database being so big, it's going to be almost impossible to go back and correct anything. Even though, companies have. There are good people out here that have been trying to clean that up and provide the right information, but it's a very difficult task. Most other organizations have the policy like Carter was describing, where you can make a general statement that says, I participated, I'm willing to do FRAND for this standard, for anything that turns out to be essential. That's Intel's preference in most cases. We're in about 300 different standards bodies, about 500 different technical committees. If we had to go through identifying individual patents, we'd be spending all of our time on legal expenses and not doing standards development. We can do it in areas of concern, like the telecommunication standards. But, so for over-declaration, it's largely a problem when people feel that they must disclose something even though it's questionable. It's not really a major problem in the IT standards, because, again, people are not necessarily looking for royalties. They're looking to use their patents defensively.
And Carter, you had some thoughts on over-declaration as well.
Well, there's DVU's policy, of course, you don't have to worry about because no one declares. But the European Commission is wrestling with the issue. They're trying to. The European Commission is looking at how to make quicker assessments of essentiality to provide greater certainty to the market about which patents are truly essential. And they have a couple of proposals out there, including using the European Patent Office as a mechanism for doing an essentiality check. Another mechanism for reducing the weight of over-declaring is through licensing programs, through patent pooling and similar licensing programs, where an outside specialist is commissioned by the patent pool administrator to review the claims of essentiality for each of the patents that are to be admitted into the patent pool. So there you have a greater assurance of the essentiality when you're taking a license from a patent pool.
And Patrick, you had some thoughts on, from an implementer's perspective, whether the issue of over-declaration is an acute one, or if they're dealing with the patent pool, whether they don't care. So.
Yeah, I think our point of view is that the issue of over-declaration is a symptom of a larger problem that we see, which is, I guess, what I will call patent over-proliferation, or to use an older term, some people used to talk about patent thickets. Essentially, the idea is that we have gotten to the point where we are no longer creating patents just as a result of sort of a normal offshoot of R&D activity and so on. We're actually creating patents because other people have patents, and it's a kind of it's a competitive environment, and it's an ever escalating process that just creates more and more proliferation. And one of the symptoms of that is what you see talked about here, which is over-declaration. The idea is that if you over-declare, you can swamp the process with an insurmountable analysis burden, and in a sense win because you have more than anybody else, and you win by numbers rather than actual innovation or patented technology. And our view is just that is a symptom of over-proliferation, and we think that's how to address the issue, is to address the issue of patent proliferation.
Earl, you had thoughts on additional underlying causes of over-declaration and the presumption of disclose it or lose it.
Well, I think we've kind of hit on the things that I wanted to talk about, and the point is very well taken that there are an awful lot of patents that are, when challenged, turned out to be invalid or not infringed. When we're talking about essentiality, the essentiality is whether or not the patent is self-declared to be essential to the standard. And that's a very subjective personal opinion, which is subject to a lot of debate. And as I said, the European Commission themselves have said half the ETSI database is probably not essential. And that's in general. Depending on particular people, that number can be as low as 10%. The amount of energy you put into it for determining essentiality doesn't reflect what happens if you go to court and challenge a patent. Even if your patent is shown to be essential, does that person in particular infringe that patent? Lots of times people show up with a portfolio of patents and say, you have to take this large portfolio, even though you use only a small percentage of these patents. and that becomes a negotiating problem. And then you also have the problem of, well, if challenged, how many of them are actually going to survive a validity test? It's my understanding that the European Patent Office fares a little bit better than the US Patent Office in that respect. But a large number of patents, when challenged, get shown to be invalid. So the poor company, especially if they're a small or medium-sized enterprise, when they're looking at this huge challenge of overinflated database, claims of having patents, claims of having essential patents, this is very difficult to deal with. The way I think it needs to be dealt with is, we need to ensure that patents that are issued are very solid, and they should be good, strong patents. Patents that are weak or should never have been issued in the first place should be eliminated. And the royalties really need to be fair, reasonable, and non-discriminatory. You don't get added value just because you're licensing the same patent with the same patent claims at a different level in the supply chain. If you didn't add any inventive step that increased the value of the product, you shouldn't be entitled to any additional royalties. So it's an overly complicated environment which could be benefited greatly with patent health as well as really looking at how royalties are determined.
So how about the opposite issue? Is there a concern regarding under-declaration, where a company pushes the development of a standard towards technology that they have patented, but they don't fully disclose their patents in that area? Carter.
Well, there are cases about that. There are cases, notably the Rambus case, where there was a company that did not disclose its patents that were essential to a particular work item going through a standard setting body. And at one point in the litigation, it was ultimately vindicated otherwise, but in one point in the litigation, it was found to have violated antitrust rules. There's another phenomenon as well, and that is that the kind of the reverse phenomenon, which is that within a standards body, the technology contributions are pushing into a particular direction, and there's an additional feature or an additional functionality which would be very attractive. In fact, it's very compelling, commercially compelling. But the standard setting body does not reach, the specification does not reach that particular functionality. So someone is sitting, owning a technology for that additional functionality outside the standard, where that company is not bound by the FRAND obligation. So yeah, I guess there is a problem with under-declaration. And once again, I have to say, I have the caveat that in DVB, we don't call for positive declarations. And in DVB, we have never had a negative declaration. So it's what I observe in other situations.
Thanks.
And I would add that going beyond the inventive space of what's involved in the standard, that may be exactly what we want to do. We want to encourage people to be innovative, to be able to compete with things outside of the standard, to offer other technologies, et cetera. If someone really has a good idea on how to do that, it might not be appropriate to have it standardized. That might be their proprietary advantage, and that's where they should be able to compete. This is also why we have the negative declarations, because there have been many instances, not in DVB, but in other areas, where people have tried to go in to a standards organization and pull in the proprietary patented technology of another company. In which case, that other company definitely has the right to say, no, I am not willing to license that.
And Patrick, you had thoughts on under-declaration and how that might affect the reputation of the company or the standard?
Sure, yeah. I think, so I've sort of been talking about the parallel process of creating common technology that we call open source. And because it is a merit-based process and companies don't have to work with one another in the process, they do so by choice, reputation in that community is a very, very important element. And so there's a bit of a self-governing element to it. So if someone was known to participate in processes, essentially hide that they have patented technology, and then come back later and try to monetize that, that would be extremely damaging to the reputation in that community, and companies would not work with them going forward. And I do think that's an advantage I see. I think there is a reputational element in more traditional standards setting activity, but I think because of the way the bodies are set up and participation at some level can, you pay the fee, you sign the agreement, you show up and you get to participate regardless of your reputation. I think it isn't quite as self-correcting as perhaps a more merit-based system like open source is.
So how are standard developing organizations governed when you've got all these members? How are decisions made? How are votes counted? Is it one company, one vote, or can it, be skewed in favor of one party or another? Carter?
Well, there's a great deal of focus on that today. There's some academic literature that recently came out having to do with balance within standard setting bodies. And I think we'll have a speaker later on today who helped write one of the leading articles on balance. Generally speaking, it could be one member, one vote. There's, in DVB's experience, sometimes we've had affiliated companies join. And so because despite the fact that they're all part of the same general company, they maybe have two or three votes. But to date, there really hasn't been, within DVB, there really hasn't been any abuses by people getting multiple memberships. Also within DVB, for balance, for our senior, in our most senior governing body, which is called the steering board, each of the constituencies within DVB has a certain number of seats. For example, we have a manufacturers constituency, we have a broadcasters or content providers constituency, and we have an infrastructure providers constituency, which is companies like telecoms operators, cable operators, and satellite distributors. And finally, we have a fourth one that's called regulators, and we have a number of European regulators who also have a constituency. So this is how we achieve balance within DVB. But I think there's and Earl, do you want to address the issue that has recently come up about?
Sure.
Yeah.
Clearly, one company, one vote is a hard-won idea. We've had pain in the past. There's several famous antitrust cases where people have attempted to bring in outsiders to skew the votes, just to get people to participate. There's one famous case where people brought in people off the street. They basically brought in their relatives, people off the street, people that didn't know anything about the technology in order to do a vote. That was an antitrust problem, and that the antitrust authorities came down very heavily. In ETSI, the technical committees do generally operate on a consensus idea where they're trying to get consensus of the people participating. If they're actually cornered on something, they prefer not to vote. They try to reach a consensus, but if something has to come to the ETSI General Assembly, the ETSI General Assembly is configured in a way that it supports companies that have business entities in Europe. So it's going to weigh heavily in favor of companies that have business entities. You can pay up to a certain amount. It's like up to 45 votes for a particular entity in a particular country, and you can have multiple entries in multiple countries. So companies that have money and lots of entities can wield a lot of voting power in the ETSI General Assembly. And there's also a balance there where the European countries that are responsible for the framework of ETSI have their own voting procedures and rules which can take precedence over the General Assembly. So it's a complicated environment. There has been some criticism of ETSI's environment, but it is what it is, and it has been working. You can make your own determination on, if you're interested, I would look into it more carefully.
Patrick, how does the open source community react when they see technical standard being developed by a standards body with regard to some features that the open source community might be interested in?
Well, they tend to, I guess I'll speak from Red Hat's perspective. Obviously, we respect others' intellectual property, and we want to distribute code that is properly licensed and has the proper rights associated with it. And so, in some cases, if a standard is developed in a manner that where quite literally an implementation of the standard is not possible under whatever open source license would apply to the code, then we've got to figure out some way to deal with that, and won't ship the technology. So we'll come up with a competing technology, or simply leave that to, in some cases, leave that to end users to solve that issue. So sometimes end users will get a direct license to a technology and install it after they receive our software. So, but the main issue is that the community does not want to be distributing patent encumbered code without a license.
So as our time winds down, we're going to hopefully have time for audience questions, but let me ask each of you guys, where do you think standards developing organizations can improve? Carter.
I think one of the things we found very effective in order to give greater certainty to the market, especially relating to IPR questions, is to foster the formation of patent pools. It's worked for DVB, and recently, over the past 2 or 3 years, we've become sort of evangelists on this, and we've advocated this to other standards bodies. And then there's been a demonstration, not with the outcome that people expected, but there's a demonstration of our pool fostering effort when it was applied to trying to choose a single administrator for the new video codec adopted by MPEG called Versatile Video Coding. So that's one aspect. And then also the other aspect is, once again, going back to DVB's experience, is encouraging the use of a more streamlined approach to resolving disputes involving IPRs that are essential to a standard setting body's standards. And we've chosen arbitration. And I know that Earl Nied wants to ask the question about, Carter, how many arbitrations have there been since 1997? And Earl, I have recently reviewed the files of DVB, and I've been legal director or in a similar position with the DVB since its inception, and I can report that I'm aware of 0 arbitrations. So either our choice of arbitrator has failed and no one wants to go to arbitration, despite their obligation to go to arbitration under certain circumstances, or people shy away from arbitration, and they find their way to entering into licenses with each other. So those are the 2 aspects. Creating licensing programs that make sense for easy administration of of IPRs, coupled with perhaps lower aggregate royalty fees, and that's through patent pools. And then the second aspect is alternative dispute resolution, notably arbitration.
Earl, your thoughts on improvements?
And so there's a lot of good things in what Carter just said. You know, I would submit that in DVV's environment, there just aren't that many disputes, especially with the number of patent pools that are there. And DVV is very fortunate to be able to have working patent pools that, you know, some people might think one or two is excessive, but it's a working environment. Not everybody is interested in joining patent pools. Some of the biggest patent holders refuse to join patent pools. And this has played out in a number of areas recently. And now there's, you know, some big debates going on in the codec space about, you know, whether some patent pools for some things are going to be successful or not. I would say that a lot of the answers have to come from the outside. These organizations, I'm looking at Christian's notes from this, and he was saying, you know, these points are, you know, when you're talking about IPR policies, they get very contentious. And the organizations are member-driven, so it's very difficult when you've got, you know, polar opposites arguing for something in an organization. That can be affected by the antitrust authorities, where antitrust actually has a role to play. That doesn't always have a role to play. It can be affected by patent valuation arguments. It can be affected by the courts. It can be affected by whether there will be, you know, success in finding people to be able to do independent and good evaluations of essentiality. All those things kind of revolve around the outside of the standards organizations. I'm not trying to dismiss the responsibility of the standards development organizations, but they're basically technical bodies designed to create standards. They're not legal bodies with the money and energy to be able to do a lot to deal with disputes between members and legal issues around licensing.
And Patrick, your thoughts?
Yeah, well, put simply, I think standards bodies should make it easier to implement their standards in open source. And this would be done through IPR policies, specifically IPR policies that specifically contemplate open source implementations, and in particular, in some cases, what are known open source implementations under what are known as reciprocal licenses, things like the GPL, LGPL, those sorts of things, because open source is here to stay. It is one of the major ways of developing and distributing software today, and that will only continue to grow. And to pretend otherwise is to be stuck in the past.
All right, thank you. So I think we have time for maybe one audience question. Sorry. Any questions?
There, I see a hand.
Hi, I'm Matt Lynd here, Cornerstone Research. Thank you so much. Very informative panel. Carter, I was curious that there's been, even though DVB encourages arbitration, there haven't been any successful ones yet. And on the issue of success in promoting pools, is that because you've been encouraging balanced participation? I mean, that's one of the academic issues with pools. It needs to be balanced participation, so you get people putting in valuable patents and you get a fair valuation at the end of the day. What's been your success, do you think, in that?
Okay, there's a bit of an echo, so I'm not quite sure I fully understood the question. It was the ensuring a fair valuation of the patents that are included in the pool? Okay. Let me just, So we're focused. Our most noteworthy pools are in the lower left-hand corner. Our transmission standards for DVB S2 and T2, but there's a bunch which are managed by SysVal. And the process of pool formation, and this is after we end our work within DVB and fostering, then it goes on to a patent pool administrator who brings together the licensors who are interested in forming the pool, and they engage in this negotiation for setting the royalty rate, and also for distribution of the proceeds of the payments that are made by licensees. If the question is whether the royalty level is truly fair, reasonable, non-discriminatory, and how they arrive at that, it turns out that in DVB's experience, many of the participants in the pool are also licensees, and so they will be spending their time looking out after their own interests and making sure that it is in fact truly a market rate which it comes out. And our pools have been fairly successful. We haven't, or rather, SysVal's pools have been fairly successful. There hasn't been yes, there can be contention in negotiation, but there has been very little pushback at taking licenses.
I'm sure.
I hope that I answered. I hope I answered your question. Okay.
I'm sure others have questions, but unfortunately we're out of time. So I want to thank our panelists, Carter, Earl, Patrick, thank the symposium and the sponsors, and thank our host, Bauz IP Law, and thank you, the audience, for your attention.
Before we close the 2022 Global Brand and SCP Symposium, I just want to acknowledge some people who helped make this possible for all of us. I can't read all the names, but you'll recognize the faces. It's been wonderful to see old friends and meet new friends. Another acknowledgement is to our platinum sponsor, McCool Smith, who, like all our sponsors, helped to make this event possible. I'd like to thank Cater2, our caterer, and FN Tech, who did a wonderful job producing this event. Thank you to all of them. And of course, thank you to the Executive Director of Bauz IP Law, who put in an enormous amount of time to make this such a fabulous event. Thank you, Maria, for your help. And now the Computer History Museum has done a wonderful job as well, and they're leaving 25,000 square feet of their museum open for us during the networking reception. So thank you to the Computer History Museum as well, and we look forward to seeing you downstairs where there will be not so small plates to enjoy. And thank you for those remote participants as well who joined us from 3 continents, as well as our speakers and moderators who also joined us from 3 continents. Thank you very much. Enjoy.